we ready? Start. Learned counsel for the petitioner has invited our attention to RTI application made on 24/6/2013, specifically soliciting the answer to the query of no decision being taken for 6 months on the bid of the petitioner and inquiring whether the bid had been withdrawn. Annexure P6 stop. In answer to the same white a letter, it has been stated that the tender process is complete and as per item number 15 of instructions to tenderers, the railway administration reserves the right to reject or accept any tender without assigning any reason. Stop. Learned counsel for the petitioner submits that aforesaid clause cannot give a license to the respondents to cancel the tender without recording the reasons for the same, and in this behalf relies upon the judgment of the Supreme Court, which states as under. Stop. Coming to the second question involved in these appeals, namely the rejection of the tender of the writ petitioner, it was argued on behalf of the applicants that the railways under clause 16 of the guidelines was entitled to reject any tender offer without assigning any reasons, and it also has the power to accept or not to accept the lowest offer. Stop. We do not dispute this power provided the same is exercised within the realm of the object for which this clause is incorporated. Stop. This does not give an arbitrary power to the railways to reject the bid offered by a party merely because it has that power. Stop. This is a power which can be exercised on the existence of certain conditions which, in the opinion of the railways, are not in the interest of the railways to accept the offer. Stop. No such ground has been taken when the writ petitioner's tender was rejected. Stop. Therefore, we agree with the High Court that it is not open to the railways to rely upon this clause in the guidelines to reject any of every offer that may be made by the writ petitioner while responding to a tender that may be called for supply of spare parts by the railways. Stop. Learned senior counsel appearing for the EDC drew our attention to a judgment of this court which has held. Stop. Under some special circumstances, a discretion has to be conceded to the authorities who have to enter into contract, giving them liberty to assess the overall situation for purpose of taking a decision as to whom the contract be awarded and at what terms. Stop. If the decisions have been taken in bona fide manner, although nor strictly following the norms laid down by the courts, such decisions are upheld on the principle laid down by Justice Holmes that courts, while judging the constitutional validity of executive decisions must grant certain measures of freedom to play in the joints to the executive. Stop.